big part of it is your estate planning. Are there any other benefits that you get while you're alive for having the trust, or is this something that you could do? I mean, I know you can't plan when you're going to die, but is this something that you see the older people do more often, or is it good whether you're young or old?
And it's usually those big life events that should kind of trigger those responses to thinking that you need an estate plan. Like, I partner with a lot of realtors that talk to their clients about it as well. So a home purchase, having a baby, even getting married, you don't need to have a kid to know that you need to look after your wife or husband, should there be an emergency or something important happen. That's when you need to start thinking about this, not waiting until you're 60 or 70.
Welcome to the Landlording Show. My name is Tim Harson. I'm your host, and today I have a special guest, two special guests actually, both from the Security Benefits Center. I have Ben and Tim, who help with estate planning, help with trust, and when you're investing in properties, these are things that are protect your family and help you build that legacy. So welcome to the show, guys.
Thanks for having us.
Yeah, thanks, Tim. We're excited
to lead here. But if you guys want to tell us just a little bit about what your company does, and then we can dig a little bit into the weeds of estate planning and things like that.
We do a handful of different things. Estate planning is really one of our largest focuses. We've got a pretty large estate planning team now. So we do work with both different types of trusts. We don't have limitations on what we can do on the estate planning side of things. And we try to kind of go a step beyond that a little bit. There's a lot of other services that come into estate planning. You can protect things from probate, but taking a look at the tax implications that happen can have a pretty big impact on what happens with your family's future. So we've got a whole team designated to tax and financial services. And then Tim is part of it as well on doing different types of educational classes for estate planning and other financial services also.
Very cool. I know you said two types of trust that you guys can do. Can you talk about those a little bit, what the two different types are?
Yeah, the two key big ones are revocable and then irrevocable. And there are pretty big differences. The typical one, that the average American family is going to use is just a revocable living trust. The nice part about a revocable trust is that we don't actually change ownership too much at all. You don't have to give up control of assets, which is unfortunately what happens in an irrevocable trust. And there are some pretty big benefits to an irrevocable trust, especially when we start to talk about concerns with the expenses included with long-term care. And once Medicaid kicks in, an irrevocable trust can help protect some of our assets from that. But there's some unfortunate sides to it as well. So that's kind of the types of things that Tim and I are always analyzing when we're talking with people, is figuring out, although there's some parts of an irrevocable trust that may sound great, giving up control over our assets is never ideal. So if we do take that route, we want to make sure that it is going to fit properly and not end up with a bunch of different hiccups and roadblocks down the road.
Yeah. So trust, and I think there are some benefits in terms of protection and sort of similar to LLC type protections when you have a trust, correct? So you're taking the property a lot of times out of your own name. And sort of moving it over. But are there any other benefits? I know that obviously the big part of it is your estate planning. Are there any other benefits that you get while you're alive for having the trust, or is this something that you could do? I mean, I know you can't plan when you're going to die, but is this something that you see the older people do more often, or is it good whether you're young or old?
So kind of two parts. But so estate planning as a whole tends to happen on average after the age of 60. It's not necessarily that that's the only time it should happen, though. I've told a lot of people estate planning is kind of a relative term. It's more of an umbrella. And then inside of estate planning, we've got trusts and wills, power of attorney documents, all those different types of things. So first, really, the second that almost anyone turns 18 years old and you're a legal adult, having a power of attorney and medical directive documents in place is really almost a necessity. Although you might be 18 and we're not really worried about health concerns and things like that, if something bad does happen and we're unable to speak for ourselves for really any reason, we want to make sure we've got forms like that in place so that somebody can step in and take care of things while we're hopefully healing. And then on the estate planning front, kids usually tend to be the big milestone where people start to think about a trust, or they want to make sure they've got life insurance. So if something happens, a kid is taken care of, or their kids are taken care of, which is great. And it's an excellent first step to have things like life insurance. But if we do have kids, there's other big concerns like guardianship provisions that we want to make sure we have in place. We don't really want to end up needing the government to tell us, yeah, your kids are now going to be taken care of by this person, which almost always becomes a family member and it ends up the right way. But if we have those guardianship provisions in place and we have a trust in place, it helps keep the whole process smooth and really almost immediate. So even for people in their 30s, if you are just having your first kids, it's still a great idea, if not really almost a necessity, to have some kind of an estate plan together.
And it's usually those big life events that should kind of trigger those responses to thinking that you need an estate plan. Like, I partner with a lot of realtors that talk to their clients about it as well. So a home purchase, having a baby, even getting married, you don't need to have a kid to know that you need to look after your wife or husband, should there be an emergency or something important happen. That's when you need to start thinking about this, not waiting until you're 60 or 70.
Right.
So I know you guys brought up 18 and first child and marriage and all that stuff. How easy or hard is it to change things? If I'm going through life, I'm 18, my mom might be who I want to talk for me, but when I get married, now the wife takes over. So how hard is it to change things like that?
So that's something that's been one of the biggest problems, I'd say, historically, with people that purchase estate plans. You go through a legal agencies, you can pay upwards of $5,000 or $6,000 for a comprehensive estate plan, and whenever you want to make a change, you're looking at $350 an hour for a lawyer to sit down and make those changes. So something we were pretty passionate about when we started doing the estate planning is to try and encourage younger people to start doing it. So whether you're 20, 30 or 40, all of our estate plans, it's a one-time fee, and there are absolute zero cost with us to do any of the changes. If you need to update your power of attorney, update your will, update some of your medical directives or power of attorney, we don't charge you a penny. The only time there will be an expense is if something changes with a trust. If you want to do a transfer of, say, a property in the trust, there will be a small fee through the state for the redeeding, but that's typically around $200.
Well, you guys have any issues? You're speaking of redeeding, and a lot of times, again, I don't have too much experience with the trust side of things, but this is just from an LLC side. A lot of people will buy the property in their name and then redeed it. And there's always that fear that the bank's going to try to claim it back or call the mortgage. Have you guys dealt with that at all? Or do you guys have any ideas if there's any issues when you're redeeding into a trust with your loans?
So we haven't had any issues on the revocable side, because with the revocable trust, you're pretty similar to how an LLC works with, kind of a flow through ownership treatment. Like from a tax standpoint, really not that many things change all that much. The trust kind of works a similar way. So if you're in a revocable trust, we really haven't ever had any issues with that, because the owner is still liable for everything. In an irrevocable trust, the story can change a little bit, because the irrevocable trust actually has an EIN assigned to it. It's actually taking legal ownership over it. And the owner of the irrevocable trust actually doesn't have the control to just sell that property on their own discretion anymore. So that can get a little bit hairier. But like I said, for the majority of people who are using a revocable trust, which is the vast majority of Americans, we don't run into any issues with homeowners, mortgages, or insurance or anything like that.
Well, so all right. So you talked about irrevocable trust and not having the free will to sell. Can you dive a little more into that? Like, what are the steps? And we got a lot of realtors that listen too. So, like, if someone has a property there, what do they need to look out for if it's irrevocable?
So in the irrevocable, the two big differences is at some point a trust has to have an EIN number attached to it, basically the trust social security number. So you start to file tax returns for it and things like that. In an irrevocable trust, we do that right away while the grantor, which is whoever the person is who's setting the trust up, they own the assets. We'd set that up immediately, but the trust has now taken over ownership of it, and the grantor no longer has the rights or the allowance to just sell the property, take it out of the trust. We actually have to have permission from beneficiaries signing off on it. It's a little bit more of a in-depth process to be able to put things in or take things out of the trust now. And we don't have any of those issues with the revocable trust. The revocable trust, we're not giving up any of that ownership. We're also not assigning the EIN number to a revocable trust until the grantor or both grantors, depending on the situation. If it's a married couple. Once they've both passed away, then we're assigning the EIN number and the trust is taking over complete ownership of everything. Almost, in a sense, becoming irrevocable.
Gotcha. So basically, it's revocable until you pass away, which then you can't revoke it because you're dead. I know it's a blunt way of saying it, but that makes sense. I guess a couple questions. We had a couple people that listen to the show send us in some questions. So I just want to go through some of these. I know we talked about a little bit about the pros of why you're still alive and cons, but any other pros and cons of going in a trust, in terms of estate planning or anything that you guys can think of?
Yeah, the biggest deal with the trust is you're going to avoid probate. Typically you can take up to a year for any distribution of assets if you're going through probate court. Doing it through a trust, you're talking weeks, if that, to get the distribution. You're also skipping any fees associated with the probate court, which can range anywhere from about 5 to 10%. Which, if you start dealing with some big numbers, that's some money that can be going to lawyer fees and to the government. That why should they be taking that money from you, right? And also because it doesn't go through the court process, it doesn't become public knowledge. So you gain some privacy of where your assets are being distributed as well. But again, it's not just houses that can go in trust. There can be lots of other things as well. Yeah.
I was going to say, kind of following up on that also, that's definitely the biggest one. Most people we talk to, their biggest concern is they did probate with their parents. They had to go through that process, and it was horrendous. And it's not fun. There's a handful of reasons different things go to probate. Passing on assets is probably the most common one. The other really big one, though, also, and it probably impacts most of the people that you talk with, is there is an estate or inheritance tax exemption that comes with trusts. It differs state to state a little bit. So in Michigan, it bumps up. It's right around $5 million. So if you do have several rental properties, or really if you have an estate that's in the X millions of dollars, you can help save some of those taxes. That's always kind of on the back end once you've got an estate plan together. Then you dive into that nitty-gritty tax side of each asset, what's going to happen to it. And the trust can help make a pretty big difference and save on a variety of different taxes, especially when we talk about property with different capital gains taxes. Like I said, it's important to kind of understand each state's rules around it. But you can help save in some cases, and Tim and I have both run into this, you end up saving tens, if not in the hundreds of thousands of dollars range, instead of that having to come out of the estate right out of the gate.
I know Tim mentioned that there's other things that you put into a trust besides properties. What are some of those, or what else do you see people put in trust?
So that's a little bit dependent upon each person's situation. So property is a really big one. That almost always goes in. We also fund in bank accounts. Make sure that when we pass away, a bank account goes straight into the trust. It tends to be pretty important to have some sort of a cash value in an estate, because even if we have a perfect estate plan put together with the trust, there's going to be some expenses. There's going to be some taxes and things that have to be paid. So it's very typical to fund life insurance policies into a trust. Those are really nice because they're tax-free, so the trust can immediately take over the death benefit in those policies. And then, oftentimes that cash value just sits there in a bank account within the trust, and it can be used to cover expenses before it's distributed out to people. And then there's the retirement accounts tend to be the big one that people ask about. Do I need to fund my 401k into my trust? And typically we want to be really, really cautious about that, because inside of pre-tax accounts, any 401ks or IRAs or 403bs, a taxable event is going to happen somewhere. And depending on how in-depth you want to get, there were some inheritance legislation changes inside of accounts like that on how those accounts have to be withdrawn. So you used to be able to withdraw that account over your life expectancy. Now you have RMDs every single year for 10 years, and you have to drain the entire value out of that account. So there's a taxable event that's forced to happen over the first 10 years that you inherit an IRA or a 401k. And whether that happens inside of a trust or just happens to the person who inherits it makes a really, really big difference. Because basically, once you get around $14,000 of reported income inside of an estate, we're in the 37% tax bracket already. Where if you're a single person who inherits it, that's not going to happen until several $100,000 down the road. So there's certain reasons we'd go one way or another. It just depends on how we're looking at leaving those assets. And that's part of what we dive into with people during that funding process, is making sure that maybe it is something that needs to stay outside of the trust. Fortunately, IRAs and 401ks do pass outside of probate, so we don't have to worry about probate taking over. But if we have concerns, or if we're putting in things like spendthrift provisions or rules around how a beneficiary can access money or what they can use money for, that's where a trust comes into play to make sure that it's only going to be subject to those rules if it's inside of that trust.
So just in how it works, let's say you have investment property, and I know you're talking about the 401k, so I guess this sort of relates, but you have investment property, you're collecting rent, you're collecting, things like that. I know you mentioned about having to be, sign off for the selling of a property or et cetera. How does it work when it comes to collecting rent and using that cash flow to fund your life?
If it's owned inside like a revocable trust?
Yeah. Like, is it just passed through to yourself at the time, or is there?
Yep. So really nothing changes. So because we have the property held in a revocable trust, there is no, we're not filing a tax return for the trust or anything like that. Mm-hmm. So all the income is still going to be reported directly to whoever that property owner is or whoever's renting it out. So really nothing changes on that front. Different story if it's owned by the irrevocable trust, because we do have to file tax returns for the irrevocable. The irrevocable trust is going to be reporting that income. So that could put us into a tough tax situation. Because again, if you were to put 5 rental properties that are all making $1,000 a month for rentals, we're bringing $5,000 a month, over 12 months, that's like $60,000. And the majority of that income is going to be taxed at a 37% rate instead of, if it's taxed on the homeowner or the property owner, it's probably a 12 or a 22% rate.
Talked a little bit about this, but I'm just going through the questions that the people who listen have sort of asked us to do. But in terms of, I know we talked about selling a property. Basically, it's just a matter of getting the signatures of the beneficiaries, right? That's the only extra step for the most part.
Mm-hmm. Yeah. Signing off with beneficiaries and successor trustees, which, typically in a perfect world isn't a big deal. The only horror stories I've heard is if a beneficiary didn't agree and they really, really wanted whatever the asset is, if it's a house or anything like that. But the grantor, the person who actually bought it and owns it, wants to sell it or liquidate it for whatever reason, then we kind of end up with our hands tied. And those usually, fortunately, it's uncommon to run into situations like that, but we end up in legal cases trying to get that settled out.
Cool. So another question we got. A lot of our clients and a lot of real estate investors will put the property in an LLC. They'll deed it to an LLC. can the LLC then put the property in a trust, or do you have to deed it back to yourself to do that? How would that work?
No, the LLC could definitely it can go into that. Same way as you can own the LLC, it can be direct into the trust. From a grantor standpoint, that's really the only thing that changes. But like if I own an LLC and I'm putting the LLC in the trust because I wanted to avoid probate, the trust is really going to work right alongside or right in between those two. So it's not like it would cause any hiccups or anything.
Cool. And then, is there any other like ongoing fees of having a trust? If you have a trust with $1 million in it, is there? I know a lot of people sort of think of like brokerage accounts where if you're investing $1 million, there's all the fees for maintaining it. Do trusts have similar things, or?
So the only typical thing would be those changes if you're going through a lawyer. If you did it with one of the companies that charges you to come in and make the changes, there would be changes for updates. But again, through our company, we never charge for any of the changes or never the updates. But there's nothing just to keep it alive and keep it going.
Oh. And then the question that's always not as fun to talk about, but what happens when you have a trust and you actually do pass away? What can you walk us through sort of what happens to the trust and what the process is for I'm assuming kids, your wife, or whoever's getting the trust, the beneficiaries? What sort of process would they go through?
Yeah, so
you can go ahead.
Okay, so thank you. So if the person that has the trust, that's the purpose is, you name an executor, the executor would take over the trust. On the trust, you also have the option to list alternates. In the event that all of the alternates have passed away, it means you didn't take advantage of your free updates and didn't make changes, as needed, or there was a horrible situation where everyone might have perished in one situation. If that does happen, then that's typically when the trust would end up in probate and would have to potentially go through the process. But as long as we're keeping it updated and you're letting us know when you want to make changes and we update it and keep it updated, then that shouldn't be an issue. We should be able to keep the executor on there and the alternates to where that wouldn't happen.
Yeah, and just piggybacking off that, if there's kind of two different parts to estate planning. And so there's creating an estate plan, then there's settling the plan, which is really, that's what we spend a lot of our time doing as well, is on the back end, making sure the estate plan actually functions properly when someone does pass away. And so, like Tim said, we've named who our executor is. And that, you might have heard the term executor or successor trustee. So whoever is filling that role, that person is taking their fiduciary obligation to do what's in the best interest of the trust, and then also follow all the rules and the guidelines that are laid out in the trust by the grantor, who in this case is recently deceased. So they basically immediately take over control of the properties, the bank accounts, the life insurance, whatever those are. And then depending on how we have the trust laid out for our beneficiaries to receive all that money. So if we're giving it to 2 kids and we have 1 successor trustee or executor, maybe the rules in the trust say that, upon passing away of the grantor, for 15 years, once every 5 years, they receive a third of the money that's in the trust. We're kind of liquidating everything and just splitting it into thirds. So the successor trustee or executor is the one who's in charge of investing those properly, or figuring out where are we going to hold money at for the time being. If there were rental properties in it, we were planning on keeping those properties. They'd be managing them or working with a management company, and the trust would just be receiving that income and then distributing it out to our beneficiaries. So we're not passing ownership, but we're passing control of all the assets in the trust to our executor, who's then responsible for distributing it to our beneficiaries.
When you distribute, let's say you have a plan where you're distributing it over 15 years, or that example you gave, does that help with taxes as well? Because instead of having a lump sum income, I'm getting it, split into 3. or are you getting taxed on the full lump sum still?
So it would just depend on what the asset is. So if it was like a 401k, that 401k is still subject to the 10-year rule, or the Secure Act rule that passed in 2020. It's the legislation I was talking about. Mm-hmm. So the trust is the one who would actually be taking the taxable event. So that would kind of probably not be the best situation, because they're going to pay a bunch of taxes. So really what the beneficiaries are inheriting is an actual cash value that typically they're not going to run into taxes on. In the capital gains side of things, then you're absolutely right. So if you had just a standard brokerage account and we were distributing it, over a 15-year period of time, you're going to be significantly better off taking those capital gains in 15ths instead of taking all of those capital gains on, one time where we're going to end up paying 15 or 20% on them. There's probably a decent chance we end up paying no capital gains if it's spread out over a period of time.
Now, because I know you guys do all the stuff estate planning wise. When it comes to just doing a will, or hey, I'm just getting started, I really don't have too much in property sense, and I'm doing a will. At what point do you think you would want to do the trust? Is it once you own a property, or is there a level of income or that it makes sense? Or
probably not quite a level of income. It's when it really becomes a big factor is when we have assets that are going to be subject to probate, and then when we have beneficiaries who we don't want to have to deal with probate. So home ownership is typically the biggest first one that people are concerned about. And a will is great. A will accomplishes a lot of things. Really, they're so inexpensive to get to. Almost everybody should have at least a will in place, but a will isn't going to protect us from probate at all. We still have to go to probate. We just get to bring that will to probate, and they'll honor the rules that we have laid out in it. So as soon as you have a property or other assets that would have to go to probate, then the trust comes into play. That's where we want to make sure we have that in place.
Awesome. Cool. And then the last question I got, and from one of our listeners that I know Tim wants to talk about, but estate planning and pricing. Like what is a normal company charge, or how does the pricing normally work, and how are you guys different? Because I think that's part of the reason I brought you on, is it's really cool how you guys do it.
Yeah, there can be different prices. There are some companies that will look at how much you're earning and how much they're funding before they actually give you a price. You can pay that way. I think typically you're looking for an average person, you're looking at probably $5,000 to $7,000 up front, and then with changes. So our price, because we operate a little bit differently, we have lawyers on the back end that do it. So we help with the preparation. It gets reviewed and certified by the lawyers, and then filed. We're with the notaries, so we sign off on everything as well. So our price is $1,995. However, for your guys, if we're told that Tim from Chicago Style sends them, then we knock $200 off. So $1,795 for your listeners.
It's awesome. Anything, and guys, definitely take advantage of that. If you're listening, you're a property owner, whether it's just your own house and you haven't started investing yet, or you're investing. I mean, unfortunately, even when you're young, if we could predict when we died, we're going to die. The world would operate a lot differently, I think, but you never know. You never know what's going to happen tomorrow, or if you're going to wake up. So make sure your family's protected. So I think that's an awesome deal for everyone that's listening, and we'll have all your contact info below and everything to reach out. But is there anything that I missed that you guys want us to talk about or touch on?
I think that's pretty much it.
Too much now. Make sure your stuff doesn't go to probate. Make sure you don't pay a pile of taxes on all of it.
Yeah.
Awesome, man. Well, I want to thank Ben and thank Tim again for coming on, and guys, definitely take advantage of this and reach out to them, and we'll like I said, we'll have all the information below on how to get a hold of them and how to get started, and go from there.